trouble, you can recover. He, as a defendant, have the right to go to trial. That's his constitutional right, and you are the jury pool. So from your number of what looks like to be about 40 people, we were going to draw 14 names, and you will become the triers of fact, which means you will decide whether Mr. Hamburg has committed the crime of grand larceny in the fourth degree. It is alleged that Mr. Hamburg stole from his little brother his Xbox One and the accessories in excess of $1,000. That makes it a felony, and that's why we're in county court. County court is primarily a court that hears felony charges handed down by a grand jury in what we call an indictment. And an indictment is nothing more than an accusatory document. You are the triers of fact, not the judge. You are. The judge just sits up there kind of as a referee and making sure everything goes smoothly. So what Mr. Hamburg and his attorney are entitled to, and Mr. Lemieux, who's the prosecutor, also known as the people, are entitled to, is a fair and impartial juror, i.e. jury, which means we need every one of you to come in with a blank slate regarding Mr. Hamburg in the case. You need to be open-minded to the prosecution's case, and you need to be fair and impartial to the defense's case. Now, what's most important, you need to understand, that you may have said a lot of times today, is that as Mr. Hamburg sits here, he is shrouded in his presumption of innocence, which means he doesn't need to do anything during this trial. He and Mr. Miles can play euchre for 3 days if it's a 3-day trial, because Mr. Hamburg has no burden to prove anything. That is one of the fundamental rules of our legal system. He and Mr. Miles have no burden whatsoever. The burden of proof falls on Mr. Lemieux. He has to prove each element of the crime of grand larceny in the fourth or third degree. And if he doesn't, if he fails to prove one element, then Mr. Hamburg is not guilty. We don't use the word innocent or not innocent because we are not judges of innocence. We are judges of guilt or non-guilt. Let me give you an example. Mr. Hamburg or Mr. Lemieux may have not proven one of the elements of the crime of criminal possession of grand larceny in the fourth degree. Not guilty verdict. He may have actually stolen the machine. But because he didn't prove his case, he's not guilty. And it's an innocent, not guilty. And there's a big difference. They're not the same word, they're not the same concept. So what we're going to do in just a minute, we're going to pick some people to be the jury. There are 12 impaneled jurors. They have to listen to all the evidence. And they have to keep an open mind, and they have to decide whether or not Mr. Lemieux has carried his burden. They sit in the first 12 seats. The last 2 seats are called alternate jurors. Those are the jurors that have to listen to all the evidence. They listen to Mr. Lemieux and Mr. Miles if he chooses to raise a defense, but they don't get to deliberate. Okay? Really kind of a frustrating position, but that's what the law says happens. Unless Mr. Miles agrees to allow the alternate jurors to deliberate, but odds are he's never going to let that happen. Okay? Now, again, no burden. If Mr. Hamburg wants to sleep during the day like his dad does, he can do that during the trial because he has no burden whatsoever. Okay? And you have to prove, or he has to prove, he being Mr. Lemieux, Mr. Hamburg guilty beyond a reasonable doubt. Not all doubt. We don't ask for all doubt. A reasonable doubt is doubt that a reasonable person in the same situation as you are, because you're reasonable people, might have or might not have about Mr. Hamburg's guilt. It's a high burden because we don't want people simply to be convicted because, well, we think they're guilty, or here's another one. We need open-minded people because just because Mr. Hamburg has been arrested doesn't mean he's done anything wrong. Just because he's been accused by an indictment, he's not guilty. So if you are of the mindset that, oh, he's been arrested, we're here for a trial, he must have done something wrong, then you are of the wrong mindset. Okay? You cannot have that mindset to be a fair and impartial jury. If we took a vote right now on Mr. Hamburg's guilt, you're all reasonable. Most of you are reasonable. The verdict would be not guilty because there's been no proof that he committed the crime. Okay? And I don't care if he talks or not, or if he play cards or not. I don't care. You cannot hold that against him. Okay? Because he has nothing to prove. Okay? So first, we're going to pick the foreperson. Kate Olmstead? Where are you? Come on up. You're the foreperson. The foreperson is typically the first juror who's picked and seated on the jury. We're going to kind of fast forward. Mr. Olmstead sits in that first seat. He is the person who calls the vote, records the vote, sends notes out to the court, asks questions on behalf of the jury. But he's no more important than any other jury, and his opinion doesn't matter any more than the other 11 jurors. Kate is kind of like the guy who's going to control you up back. Okay, he's going to ask for the vote and ask for the reason. Let's pick 13 more people. Well, actually, no, first I need co-counsel for Mr. Miles. The defense attorney will be Laura Moore. Congratulations, Laura. You graduated from law school in 45 minutes, and you're now in defense attorney. Good job. Have a seat with Mr. Miles. He'll help you out, tell you what's going on. Jonah Flansburgh is the assistant district attorney. Mr. Flansburgh, come over here. You graduated from law school, and you are now an assistant district attorney. We defend people to the dark side, but it's all right. Okay, so now pick me 14 names. Get right up to your seats. I'll tell you where to sit. We're going to start jury selection. Everybody open-minded, right? Nobody has any presumption of guilt because there's a presumption of innocence only in the court of law. All right, folks. Thomas, take it back. Left.
Juror number 2, Sean Miller.
Mr. Miller, come on up. Walk right up there. Have a seat right next to Mr. Olmstead.
Juror 3, Haley Bohall.
Juror number 3, have a seat.
Juror number 4, Ryan Myers.
Have you got a brother that looks like you, Mr. Myers? Have you got a brother that looks like you?
Not that I recall.
Oh, not that you recall? Okay. Good to see you. You're the better looking one, right?
Oh, yeah. Juror number 5, Gavin Dunn.
Don, come on up, please. You're juror 5.
Juror number 6, Daniel Costello.
What's the name, Daniel? 6.
Number 7, Drew Ortliff.
Orlo, you're going to take the second row, first seat, second row.
Number 8, Nina Gillers.
Ms. Gillers, have a seat right next to Mr. Olmstead, please.
Number 9, Jake Rupert.
Mr. Rupert, okay, Mr. Rupert, your mother feed you this morning? Okay.
Number
We'll find
10,
out. Let's see.
Valley Widrick. Number 11, Landon Mosher. Number 12, Lillian Clark. Alternate 1, Cole James.
James, going up, you're going to have a seat right here.
Alternate 2, Kellinger. All right. Your Honor, I present your jury selection.
So you are now in the jury box. That does not necessarily mean you're going to be jurors, but it means you're going to be subjecting yourself to questions from the attorney. Before you hear from the attorneys, you have to hear from the court, and that's not always the most exciting stuff in the world. Okay? The court gives you instructions about what your job is as a juror, and what the court and what the people and what the defendant expects from you as jurors. The main thing is you keep an open mind, and you always continue to shroud Mr. Hamburg with a presumption of innocence. And you cannot hold it against Mr. Hamburg if he does not raise a defense. Or if Mr. Miles does raise a defense, you cannot hold it against Mr. Hamburg if he doesn't take the witness stand. You cannot do that, okay? So what Mr. Miles and Mr. Lemieux are about to do is called a voir dire. They're asking you questions to see if they feel comfortable with you as jurors. Because if they don't feel comfortable, they're going to try to get rid of you one of two ways. The first way is for cause, which means Mr. Myers is going to pick on you. Let's say Mr. Myers during the voir dire says, kind of arrested, he must be guilty of something. Pretty sure Mr. Myers is going to say, I'm going to get him released for cause. Mr. Lemieux might as well, because Mr. Myers has shown he can't be fair and impartial. Now, that's for cause challenge. There's also, I say it wrong every time, peremptory challenges, which means, for some reason, Mr. Myers is just not comfortable with Mr. Myers, although he's answered all the questions the right way. I keep a fair and open mind, presumption of innocence, I'll listen to all the evidence, blah, blah, blah. But he's just not comfortable with it. So he'll say, I want juror number 1, 2, 3, 4 gone under a peremptory. I have to let him go. He doesn't need to give me any reason. But he has only a limited number of those types of challenges, as does Mr. Lemieux, depending on the charge that Mr. Hamburg is charged with. He's been charged with an E felony. Now, if he's convicted, he can go to prison. Okay, but you can't consider that. Your job is not to consider what can happen to Mr. Hamburg. Your job is only to consider whether or not Mr. Lemieux has carried his burden to prove Mr. Hamburg guilty of the charge. Understand, because he has the presumption of innocence, the burden never shifts to Mr. Miles. Never does Mr. Miles have to prove anything. A lot of weight, but the weight's over here and it never moves from over here, okay? So if you as jurors don't understand that presumption, raise your hand and say that. This is the time to be honest. If you have a bias, this is the time to say it. Say, I don't like people in red shirts. Say it. You're not going to get in any trouble because you can't be a fair and impartial juror unless you're totally honest with Mr. Lemieux and Mr. Miles. Go ahead, Mr. Miles. Oh, I'm sorry, Mr. Lemieux. I always get the order out.
Good afternoon. Is everybody excited to be here? Yes? Okay, that's a collective yes. This case will probably go on for a few days, and now that it's Wednesday, it could go into next week. Does anybody have anything in their schedule that would conflict with you being here today? Or for next week? You all could be here for that duration. Yes? Have any of you watched Law & Order or CSI, any of those crime Law & Order shows? Yes? Does anybody think that's real life? No? Landon Mosier, do you think that's real life?
I don't know.
You don't know? Do you watch those shows? No? How about Drew or Lou? Do you watch those shows?
No.
No? Who watches those shows? Do you think that's real life? A little bit? Sure. Have you learned things from those shows? Have you learned maybe terms? Maybe what petty larceny or stealing is? No? Okay. As a juror, you have to pay attention to the law and those legal instructions coming directly from the judge. Okay, so any prior definition that you have of stealing, that will come from the judge in this case, and you have to set those notions aside. Do you understand? Does anybody on the jury pool know each other? Yes, right? Does anybody think that they can work with one another if you're back in deliberations? Is there anybody that doesn't feel that way? What does that mean? Do you think that you could give others the time to speak, and will you also listen to those other voices? Maybe. Can you tell me more about that?
If they're annoying me, I'll probably interrupt.
You will interrupt them.
Probably.
Okay, thank you for being honest. That's all myself and the defense attorney, Mr. Miles, are asking from you today, is just truthful answers, so thank you for that.
I'm asking the entire jury pool, can you all be fair in this case? Can you give your full attention to the case?
Thank you for your time.
Thank you, Mr. Lemieux. Mr. Miles?
Thank you, Judge. Afternoon, folks. Mr. Hamburg and I want to thank you for being here, for giving up your time to be with us. If we didn't have people like you, 14 of you, who were willing to give up their own concerns and time to serve the system as jurors, we wouldn't have what we have. And what we have is the best system of justice that the world has ever known. And the reason that it's the best is because, as Mr. Hamburg sits there right now, he's no more guilty of grand larceny than you or I are. Does everybody buy into that concept? As Mr. Hamburg sits there right now, just because he's been charged and he's being prosecuted, does that mean he's even a little bit guilty? Mr. Olmsted, let me ask you something. If you had my job, and my job is simply to make sure that you give Mr. Hamburg a fair trial, and that you obey the law as the judge gives it to you, and that you determine what the facts are. If you had my job, how would you feel about yourself as a juror?
A little confident.
I'm sorry?
A little confident.
Confident? Is everybody with Mr. Olmsted? Anybody, if you had my job, would say I'd rather not? Yeah. And why would that be? Do you think that I should have to prove something to you? I'd have to prove that Mr. Hamburg didn't commit this crime to you? You understand that my co-counsel here, Ms. Moore, and I and Mr. Hamburg can sit there and sleep throughout the entire trial if we want to, and that Mr. Lemieux's evidence still must satisfy you that Mr. Hamburg's guilt is proven beyond all reasonable doubt. Is everybody with me on that? All right. And Ms. Widrick, you found that Mr. Lemieux did not satisfy you and did not prove all of the elements of the crime of grand larceny to you beyond a reasonable doubt. Would you hesitate at all in saying in that little room, I don't think he's guilty?
No.
Would you have any hesitation? How about if there were 10 people or 11 who thought he was guilty and you still felt, after reviewing the evidence and paying attention to your oath as a juror, if you still felt he was not guilty, would you still be able to put your position forward?
Yeah.
Everybody able to do that for us? In other words, we don't want any weak sisters back there. Everybody's opinion and everybody's vote is worth the same, as the judge told you. Just because Mr. Olmsted is the foreperson, his opinion doesn't mean anything more than the other 11 of you who are back there deliberating with it. Would you agree, Mr. Costello, would you agree that we're not here to find out the truth of whether or not there was a crime here? We're here to determine whether or not proof that Mr. Hamburg committed that crime has been proven to you beyond a reasonable doubt?
Yes.
In other words, if you, when you go back there and you're deliberating, talking the case over with your other jurors, if you feel, well, you know, I don't like this guy Hamburg, he looks like a thief, he sounds like a thief, but even though I don't like him, I don't think they've proven his guilt to the legal standard of proof beyond a reasonable doubt, can you still find him not guilty? Is everybody with Mr. Costello on that? You all understand that your verdict must be unanimous. You can't have an 11-1 or a 10-2 or a 9-3. It's either guilty or not guilty, and it has to be unanimous either way. Is everybody with us on that? And that if you have a problem when you go back in the jury room and you're discussing a bit of testimony, or you're talking about some of the proof that went in and somebody doesn't remember it, we want you to know you can come back in. We have a stenographer who takes down every word that is said in here. And you can come back in and ask us if you can have testimony read back. Judge, I'd like witness so-and-so's testimony read back. And we will basically read the testimony back to you. I've been in trials where we've read the entire testimony back to the jury because they wanted it back. So it's not a question of who's got the best memory here. It's a question of what went into the record and whether you feel it's sufficient to find Mr. Hamburg guilty. Is everybody with me on that? All right, thanks, folks. Any questions?
Do you believe Brendan Hamburg is guilty?
So, and I apologize if I skipped this step, but before Mr. Lemieux and Mr. Miles would have been able to question you or voir dire you, as the court, as maybe I told you I would have given you lengthy instructions, and they both make some very important points. And we will say it again, and we'll say it again, and we'll say it again, that Mr. Hamburg has the presumption of innocence. They can sleep during the trial, okay? So if anybody feels as though they cannot fulfill that duty, this is the time to tell them. Tell Mr. Lemieux, tell Mr. Miles, and you'll be excused, okay? Nothing wrong with being excused. We know there's certain people who don't want to sit on juries, and they'll do anything they can, short of raising their hand to say, I don't want to sit on the jury, I think Mr. Hamburg's guilty. Well, that person's not, okay? So right now what would happen in real life is Mr. Lemieux and I and Mr. Hamburg and Mr. Miles would go back into the library or the actual jury deliberation room, and they'd tell me who they want on their, or who they don't think should sit on the jury. And as I said, they can either have a challenge for cause, unlimited challenges for cause, or the prerogative. And we come back and we seat the people they've chosen. Doesn't usually happen when we get 12 on the first round. And I think Ms. Hill confirmed this. Lewis County is somewhat unique with juries because if I'm in Syracuse, I'm a defense counsel in Syracuse, and I have a client who's accused of murder, they'll probably only call in 50 people, okay? But in Lewis County, if we have someone who's charged with murder, we're probably bringing 150 people to sit out there to be picked as jurors, hopefully to be picked as jurors, because we're a small county. We have two issues. Everybody knows everybody, and a lot of people are related, and that makes it difficult, okay? What Mr. Miles didn't hit on, or neither did Mr. Lemieux, and they have previously, is does anybody think they would give a police officer, a priest, or a teacher more credibility simply based upon their title and their job? Would anybody think they would? Did everybody listen to a police officer and understand that maybe a police officer may have an interpretation of the truth of what happened, who in fact might be different than what actually happened? Do they make mistakes? Do they sometimes lie? They're human, right? Okay, so we're back. You guys have now been sworn as the jurors. Now what's going to be frustrating from this point forward for everybody is that if this is a 2-week trial and you start here on Monday, and we're lucky enough to get a jury on Monday, then for the next 14 days, you guys can't discuss this case amongst yourselves. So if Mr. Rupert and Mr. Myers go to lunch on Monday, they can't talk about the case. They can talk about football if they want, but they cannot discuss the case. Because you're not allowed to deliberate on the case until you get the charge on the law from the court. Then you become a deliberating jury. And like Mr. Miles said, there's two types of jurors we don't want. One who's going to get pushed around and not participate, and one who is so inflexible they won't participate either. We need jurors who are willing to defend their position or state their position and why that is their position. Okay? Can everybody do that, you think? Okay? Remember, we don't want the juror to go back there and say, I hate making decisions, and really get really concerned about making decisions, and especially on something like this, so you 11 tell me what the verdict should be. We don't want that person. Nor do we want the person that says, I know what I've made my mind up without listening to anybody, and you're not going to change my mind. We don't want the bullhead, and we don't want the passive person. We want active participants in the jury process. Okay? So, Miles.
You want to tell them?
Tell them the charges.
Oh, criminal charge grand larceny in the 4th degree, which is a Class E felony, and it has elements that Mr. Lemieux has to prove. If he fails to prove any one of those elements, you have to come back with a not guilty verdict, excuse me. Okay? So, I'm sorry. Typically, we'd have witnesses that would be called if Mr. Miles so chose to call witnesses, but since we don't have time to do a trial, he's going to do his summation at this point. He's going to point out what he thinks his witness has said. Although he's not under a burden to do so, because Mr. Hamburg, has no burden in this case. Lemieux has the burden, okay?
Okay, folks, the question before you is, has the proof that you've heard been presented with, is that proof proven to your satisfaction and beyond a reasonable doubt that my client intended to steal that Xbox from his little brother, and that the Xbox was worth $1,000 or more at the time he's supposed to have stolen it? Now, the words that I speak to you now are not proof or evidence of anything. Just as when Mr. Lemieux gets up to speak last, which is his right, because he has the burden of proof, just as when he gets up to speak to you, no matter how eloquent he may sound, no no matter how well he may speak to you, none of his words are evidence. The evidence you heard, and the evidence is in, and it ended when the judge took the last witness and the last bit of evidence and accepted it for your consideration. So no matter what Mr. Lemieux says to you, not going to change the quality of the evidence. And we submit to you that there is no corroborating evidence to indicate that Mr. Hamburg ever possessed the Xbox belonging to his brother, that he ever intended to deprive his brother permanently of the ownership of that Xbox, or that at the time he's alleged to have done that, the Xbox was worth $1,000 or more. So given that, I submit to you that, in fact, proof of Mr. Hamburg's guilt of the crime of grand larceny in the 4th degree has not been sufficient proven to you to convict him. And I'm convinced, as is he, that you're going to render a verdict of not guilty. And I want to thank everyone.
Thank you, Mr. Miles. Mr. Lemieux.
Just thank you again for your time and for listening to all the witnesses today. Let's talk about the facts directly from the witnesses. The defendant became upset that his law and order father kept beating him at Madden on Xbox. What did the defendant do about it? He stole that Xbox from his younger brother, all the controllers, all the cords, and obtained all of the products from that Xbox. His younger brother became upset. He didn't know where his Xbox was. He went to the sheriff's department to report a missing Xbox. He showed proof that he paid $1,000 for the Xbox and all accessories. The police went to the defendant's house and found the Xbox stuffed under the defendant's bed in a large bag. That is the testimony from the witnesses.
The people are asking you to return a verdict consistent with the testimony. We find the defendant, Brendan
Thank you.
Thank you. So the trial now has concluded. We've had all the witnesses testify, all the evidence is in. The summations have been done by the two attorneys. Now the court charges you, the witness, you as jurors, with the law and what your obligation is to do. When you come to trial, you'll realize there's a lot of stuff that's repeated, and it's repeated and repeated and repeated, okay? You know, when you watch television shows and there's trials going on and they're fake trials, you know why they never show the picking of a jury? Because it's really not that exciting, and nobody's going to want to watch it, okay? So that's why you don't see that on Law and Order or those TV shows. So the court charges you with the law, and now once you're charged, you get to go back to the jury room, and that's the first time in these 14 days that you've been able to deliberate. You've been able to talk about the case. Okay? Before this, you can't express your opinions. You can't talk about the case because that's not what your job is. Your job is to hear all of the evidence, and you don't make your mind up until you hear all of the evidence. You don't hear one witness and say, "Oh, my mind's made up," because that's not what our system's about. It's about being impartial and listening to all of the evidence. So we are going to go to the jury room right now. Hold on a second, please. Mr. Olmstead, I'm going to give you the verdict sheet. And the verdict sheet is a document indicating whether or not Mr. Hamburg is guilty or not guilty of the charge of grand larceny in the 4th degree. When you have a unanimous decision, Mr. Olmstead would be the one who comes back out with all of you, and he stands up in open court and reads the verdict, and then the attorneys will probably likely question you individually. What's your vote? Well, actually, we'll ask for a question. What's your vote? What's your vote? Okay? So let's go to the jury room, and you can start your deliberations. All the jurors sit as close to the table as you can so we don't lose track of you, okay? Everybody go back.
His dad put it in the
Red sweatshirt. We decided that kid's way too nice to be yourself.
You didn't like you being a little
No, we didn't. Okay, so this is the jury room. Really inviting, isn't it? They have white walls, no windows, no clock, no nothing. That's because what they want you to do is focus on deliberation. They don't want you looking out the window. They don't want you checking the clock. You will not have cell phones if you're jurors. Those will be taken from you because we don't want you to have any outside influence regarding your decision. We don't want you talking to people about it, which you can't do once you are selected on the panel. You can't talk to family members about it. You can't read anything about it. You can't visit the location of the alleged crime. You are isolated. You can't even tell your family what it's about. Because we don't want your Uncle John to say, oh, I know that Hamburg kid, and I'm sure he did it, and I know his dad. And that way you are influenced by something that was not said in court under oath. And that's, you cannot consider outside information. So Mr. Olmsted, you are the foreman. So what you do now is you'll ask each individual juror who are the alternates. Hellinger and your alternate. Sorry guys, you don't get to vote. Sorry, you're out. you can step back a little bit. So ask the 12 seated jurors what their vote is, and you can't challenge that. You can just defend your vote in your position, but we don't want anybody to be belligerent about it and fight and call somebody names and they're idiots. And you have to respect people in the jury room. Okay? Go ahead, take the vote.
Did I ask them separately?
Ask them separately.
Okay, just fine.
Just do a tally.
Okay, I think he is not guilty due to the evidence because it could be like not true.
Okay, fair enough.
I think it is not guilty because evidence couldn't be true.
I think he's not guilty because the Xbox could have been placed there.
I think he is not guilty because the evidence does not fully support that he did it or that he placed the Xbox there. I don't think he's guilty because someone else could have moved the Xbox.
I do not think that Mr. Hamburg is guilty today because the evidence has not shown.
He's not guilty because of his hands. I'm not sure.
I don't think he's guilty because the Xbox is already moved.
I think he's not guilty because there's no hard physical evidence.
I think he's not guilty because there's not enough evidence to prove he is.
I don't think he's guilty.
Olmsted, what's your vote? Listen, your vote is your vote. Don't be embarrassed by it. If you think he's guilty, say you think he's guilty.
Yeah, he's not guilty.
Okay, defense 3-0 today.
Jonah.
I think we need to lower the age of eligibility for jurors.
Now, what's interesting in the play you're going to read is it's about one holdout juror, first time around, 11 guilty, 1 not guilty. And it shows how juries can change their mind. Because what may be important, let's say Mr. Olmsted said guilty. What may be important to Mr. Olmsted, he needs to point out to his fellow jurors why that's important. And then maybe Mr. Myers will say, no, I never really actually considered that before. And that, you know what? I think the person is guilty. I think he did it. And Ms. Ehler is the same way. He may point out something in his decision or his reasoning that changes your mind or makes you think about something differently. Something you may have been given very minor weight to after hearing another juror, you might say, oh, it's a little bit more important than I thought it was going to be, or I thought it was. So you have to be open and willing to talk. If you think Mr. Olmsted, I'm picking on Mr. Olmsted, if he thought that Mr. Hamburg was guilty, then his duty as a juror is to say guilty, not to be swayed by the rest of the 11 of you. That's not how it works. Now you're lucky enough that one of your teachers was actually a juror, and she can tell you what happens in jury selection. I've never been a juror. Mr. Miles has never been a juror. Neither has Mr. Lemieux. Pretty safe to say we'd never be picked as jurors.
So those of you who were picked for a juror, did that feel a little intimidating when you were up there getting those questions asked? And that's exactly how it is. That's exactly how it feels a little bit. And you feel that it's a very serious responsibility that you have if you are selected. Then after the trial happens and you come into this room, usually it's not this easy. Everyone just all agrees. You have 12 people, 12 most of the time, 12 people who don't really know each other. You all have different opinions. Some people are more outspoken, some people are not outspoken. You have to try to think, you have to try to discuss, what did you pick up on, what did you pick up on? Sometimes you might hear something in the trial that I didn't even think was that important. And you discuss those things, and that's how you have to have an open mind, and you have to try to figure out, how do we get every single person to agree? It takes time.
Any questions? And I think Ms. Cooper could vouch for this. There was a 3 or 4 day trial that she was involved in, and until the jury was charged, you're sitting back here with 11 strangers, and you can't talk about what you just heard out there for the last 2 hours. Because if you do, if somebody breaks the rule as a juror and then we find out about it, then there's going to be a mistrial, which means this whole process starts all over again. So let's say Mr. Olmsted decides he wants to talk to Mr. Myers about the case over lunch, and Mr. Mosier hears it. Mr. Mosier comes to the court. We bring Mr. Mosier into the library with all the attorneys present. Mr. Mosier, what are you here for? Well, I heard Mr. Olmsted talk to Mr. Myers about the witness. And if you have not been, actually, I'll get back to that. Then we call Mr. Olmsted in, we call Mr. Myers in individually, and then we determine whether or not we think the jury has become tainted. If it's a tainted jury, it's a mistrial, and we start all over again.
We hate that.
We don't like that at all. And Mr. Mr. Olmsted, and Mr. Myers would never go back into that jury room. We'd take their stuff out of the jury room. You would have a very angry judge, really angry attorneys, a very disappointed defendant, because that person is entitled to impartiality and you following the rules. And we may have to start this thing all over again. It happened to me once, 14-day trial. They were deliberating, and one of the witnesses said, so-and-so's been talking about the defendant. We called that juror in, and we asked some questions with a stenographer. Remember, everything's recorded. Yep, I said to the jurors, I thought the defendant was a jerk and he owed my parents money. Why didn't you tell us that 14 days ago during the voir dire? So we have to dismiss all the jurors, mistrial, have to start over again. It's not what our system is based on. But we're very protective of defendants, and we should be. We don't want a country where you have to prove yourself innocent. That's a scary country. It may happen at your house, but it's not going to happen in a court of law. So, any questions? No? Okay. Thank you.
Thanks, guys.
Mr. Miles, I know you want these jurors in a couple months, don't you?
I do. Sign up to vote, and then you'll all be eligible jurors, and I'll put you on my panel.
Thank you.
So before